Members of the commission, are you okay to keep going? Okay. We have the honor of having our distinguished Attorney General here with us today. And Attorney General Wasden, we are honored that you would come in person. So the time is now yours.
Thank you, Megan. Well, it's an honor to be with you. So many of you I have known for many years, and I appreciate the service that you render to our state in so many capacities in the legislative branch of government, our educational system, and our executive branch of government, and so many other responsibilities. And it's an honor for me to be here. And it was a particular honor to listen to our two former governors speak. By the way, I was a line deputy when Governor Andrus was in office and worked with him on a number of matters. And also I was on part of the executive Attorney General staff when Governor Batt was in office. And I worked then for Attorney General Lance, and previously I'd worked for Attorney General Larry Echohawk. I wanted to quickly address two items that arose when the governors were making their presentations. I won't give complete answers, but at least an invitation for further discussion, and that is, Senator Davis, you asked about the exclusivity of the remedy, and you are correct that it is not an exclusive remedy. There are a variety of remedies, and Darrell Early from my office, who has expertise in the 95 agreement, can address that further, but I wanted to assure you that you were correct. And Dr. Rudin, you asked the question about the scientific research, and what I would say to you is to consider in terms of that question is that the National Academy of Science has made a determination that deep underground storage is the appropriate remedy for the circumstances, and that is not geologically possible in eastern Idaho. So that may play into the question that you asked. So again, I don't propose to be an expert in terms of those matters, but certainly thought that was worth mentioning in response to your question. I am pleased that I've been given the opportunity to share with you the views of my office, and please note that I am committed to the success of the Idaho National Laboratory and its mission as the nation's lead nuclear laboratory, but I'm also fully committed to the 1995 agreement. And I believe that these two commitments are entirely harmonious. The 1995 agreement is unique. It is the basis for the existing partnership between the state and the Department of Energy. It's a one-of-a-kind agreement. No other state has this type of commitment from the Department of Energy. I'd like to make a quick aside, however, and recognize Admiral Grossenbacher and thank him particularly for a number of matters. First of all, his leadership in this area, but also a number of years ago I hosted an energy conference in Coeur d'Alene, and Admiral Grossenbacher was there with his team, and they were very, very helpful. We discussed a wide variety of things, but one of the things that we came to a conclusion on is that every energy source has an environmental tail that accompanies it, and it has also a litigation tail that accompanies that energy source. Now, I love relief work for lawyers, but we have to recognize that that's the reality of the world in which we live. This agreement is also unique for Idaho, too, as well as in the rest of the nation, and that's because the agreement was signed by both the governor and the Attorney General. It was a settlement of litigation which was of profound importance to the state of Idaho, and the dual signatures by both the governor and the Attorney General assure that two constitutional officers of the state oversee compliance. Now, one might argue that it would be a lot easier just to have one signatory and then the other can just, play the political game, but it is require the two signatures of state officers. It also protects the citizens of Idaho by assuring careful consideration of the Department of Energy's compliance with the benefit of objective legal advice. The 1995 settlement agreement is the foundation upon which the success of our relationship with the Idaho National Laboratory is built. Protecting this foundation is of utmost importance to Idaho and to the future of the Idaho National Laboratory, because challenges facing the facing INL and the development of nuclear energy come down to trust. So the safety of nuclear energy is one of those issues. Consider, for example, 3 Mile Island, Chernobyl, and most recently Fukushima. Those three instances collectively represent both significant technological failures and also tremendous technological successes. Consider also the legacy of defense waste and environmental problems. Hanford, Savannah River, Rocky Flats, Oak Ridge Laboratory, Los Alamos, Paducah, Fernald, Mound, and INL are all CERCLA Superfund sites. No solution for waste disposal was really sort of envisioned en masse. It is the fear and lack of trust that is created by these examples that continues to be a drag on the future nuclear power development. Unfortunately, the history of atomic energy in Idaho prior to 1995 had resulted in no trust between the state and the Department of Energy. It was a continuous string of broken promises. It included environmental degradation without a legitimate plan of remediation. There was a fear that Idaho would become a dumping ground. Rocky Flats waste had already been brought here and buried, and Fort St. Vrain fuel was on its way, and there was more to follow. The 1995 agreement provides the foundation for solving these problems by building trust and compelling solutions. It provides the framework for a relationship of trust between the state and the Department of Energy, which was lacking. It gave Idaho a commitment that the Department of Energy would solve its waste management problems and that Idaho would not become a dumping ground. And for the past 15 years, the Department of Energy has established trust with the state by completing and meeting requirements of the 1995 agreement. And the Department of Energy must be recognized and complimented for that very significant achievement. Moreover, the 1995 agreement has compelled the Department of Energy to find solutions for waste problems at INL and around the nation. The 1995 agreement was a catalyst for the opening of the waste isolation pilot plant in New Mexico. The Idaho National Laboratory has shipped almost 60% of the transuranic waste in Idaho for permanent disposal, more than any other site in the nation. The Department of Energy has excavated and retrieved transuranic waste from over 3 acres in the subsurface disposal area. The Department of Energy has moved the majority of spent nuclear fuel in Idaho from wet storage to dry storage. The Department of Energy is in the process of finalizing treatment for the remaining 900,000 gallons of sodium-bearing liquid high-level waste. And the Department will soon finalize the treatment plans for the high-level waste calcine and submit the necessary permit application to Idaho's DEQ. These are examples of significant steps forward that were occasioned by the 1995 agreement. And the agreement was the foundation that compelled solutions. The 95 agreement will continue to leverage the department to find solutions to the even bigger problem of disposal of the high-level waste and spent nuclear fuel. By requiring the Department of Energy to remove this material from Idaho, the Department of Energy is compelled to actively look for solutions on a definitive timeline. While the nation debates the viability of Yucca Mountain or another repository site, the Department of Energy will be moving its spent nuclear fuel out of Idaho. Successful management of the Department of Energy's legacy waste and the development of solutions for those wastes has and will demonstrate to the nation and the world that nuclear energy can be part of the nation's future. The 1995 agreement has been at the heart of reaching those solutions. The 1995 agreement is also like a foundation for other reasons. The agreement laid the foundation for the site's current status as the lead laboratory of spent nuclear fuel research. It enabled the site to obtain funding to upgrade facilities for future research. It enabled the site to demonstrate its unique capabilities in expanding nuclear energy. The agreement secured $30 million to assist with the transition of the site and the local economy from its past mission. This funding was used to upgrade facilities at the site on a loan to Battelle Energy Alliance, and it included funding that was used to help the Center for Advanced Energy Research, and also funding was provided to startup companies in the region. Like a good foundation, it has room to grow to accommodate the growth of the site and new opportunities. For example, the 2008 Navy addendum, which we executed to provide assurance to the nuclear Navy that they could continue to use the site in the future while still protecting Idaho's environment. And the 2011 Memorandum of Understanding concerning commercial spent nuclear fuel that allows the Department of Energy to expand its research mission at INL and to aid the nation in developing advanced nuclear fuels. It is our hope that the work Idaho put into that MOU will pay off and that INL will be able to obtain research contracts that will benefit both Idaho and the nation. Finally, the agreement is like a foundation in that it is what holds everything together. In the absence of the binding commitments the DOE has made to Idaho, the future of the site would be plagued with uncertainty and, like many other sites around the nation, litigation with its host state, which breeds distrust and is the most expensive form of communication. Efforts to change the 1995 agreement have to be viewed critically because undermining a foundation can bring down the entire house. With that, I would be glad to answer whatever questions you may have and also let you know that Darrell Early is here to assist in answering those questions.
So he gets the tough ones?
He gets the tough ones.
Fair enough. Attorney General, thank you so much for that opening statement. I'm sure there's several questions. We'll open it up.
Chairman.
Senator Davis.
Chairman General. In your comments, you speak about effectively enforcing the terms of the agreement. But absent a repository, aren't we really left with one remedy?
In terms of, excuse me, Mr. Chairman and Senator, with regard to where the stuff is going to stay, that's basically the question. We do have a variety of remedies. Is it going to stay here until there's someplace else for it to go? I suspect that probably will be the outcome.
I see.
But we do have remedies that attach to that condition.
And there, follow-up, Chairman.
Please.
The alternative remedy, of course, is the fiscal remedy.
There's a fiscal remedy, but there are additional remedies as well. And perhaps, Darrell, if you could help us out here, because we had a discussion on this very point.
Thanks.
Members of the Commission, Mr. Chairman, the agreement, legally speaking, provides at least three remedies. Number one, we can stop future shipments, and addressing, I think, what Governor Andrus made a comment about was if they don't meet the commitment in 2035, at a minimum we can stop the problem from growing more exponentially larger. So that is one form of remedy that's available to us under the agreement. Number two, the court, we have the power to go to the court and seek whatever equitable remedies are available under the powers of the court, which would be a traditional balancing of the hardships to the state against the potential equitable issues that face the Department of Energy. And finally, there is the financial remedy of the penalty associated with that. I think it's fair to say that in the absence of an interim storage facility or a repository facility, the waste that is here will stay here, but no more waste will come in. And the court will have the power to fashion a remedy to try to protect the state's interests in addition to the financial remedy that's available.
Follow-up, Chairman. Thanks, Chairman. General, you're the longest-serving Attorney General in the history of the state of Idaho. I don't know if you and the people of the state plan for you to be here till 2035 or not. But between now and then or afterwards, do you believe the agreement is written in a way that the Attorney General or your successor has the independent right to file litigation or advance or defend litigation without buy-in of either the governor or the legislature?
Darrell, you're going to assist me on the answer to this question. Clearly, as one of the signatories to the agreement, that has enforcement responsibilities, and we take those enforcement responsibilities very seriously, as we have demonstrated with regard to the litigation over the term all, in which we did, in fact, make several trips to the Federal District Court, a number of trips to the Ninth Circuit Court of Appeals, which we undertook. I believe we took that independently. So Darrell certainly can address more specifically the question that you have posed, Senator.
Thanks.
Perhaps I'm not the best to address this question because I think it raises some implications about the constitutional roles of the governor and the attorney general. Certainly in the buried waste litigation, the all means all litigation, the governor of the state did not participate in that litigation and, in fact, as I recall, deferred to the attorney general to bring the litigation independently. I believe that the agreement itself supports that position in the fact that the attorney general is a signator to the agreement, separate or in parity with the governor, and would have the right to enforce the agreement in his own right. And that's the position that the office has taken in the past.
Follow up, if I might, Chairman, to the general. In your comments, you spoke about being able to have an independent legal review. As a party to the agreement, how do you do that?
Mr. Chairman and Senator, we have folks on our staff who are independently responsible for reviewing that. They provide me legal advice. We are also provide legal advice to the governor's office upon their request, and we also respond to the legislature upon their request with regard to the 95 agreement. And you did raise an issue as to my longevity as the Attorney General, and I will confirm that I am the longest-serving Attorney General in the state's history, and I'm uncertain as to whether I will be the Attorney General in 2035.
Thanks.
Thank you. Any other questions from the Commission? I have one, if I may. Being new to this process, there's been a fair amount of conversation around the financial penalties that are embedded in the agreement. And there are some that feel that it's an automatic penalty, that if the date comes and passes, that it's an automatic penalty. And then there's some that feel or state that there's several contingencies surrounding that it's not an automatic penalty, that it would have to be appropriated. There's other things. So can you speak to that just to help us understand the finer print in that provision?
Certainly, Mr. Chairman, and Darrell Early again will have the specifics on that.
Okay.
Mr. Chairman, the 95 agreement specifically does, with respect to the payment obligation, make the payment of the penalty subject to appropriation.
Okay.
The running of the penalty, however, the accrual of the penalty is automatic upon the failure to meet the deadline. So every year, the Congress will be presented with a budget line item request, essentially that identifies the fact that they failed to meet their commitment to the state of Idaho and that they owe somewhere in excess of $20 million to the state of Idaho every year accruing forward from that date forward. So while some people have said it's a drop in the bucket, it perhaps at least keeps the issue in front of people and would continue to accrue going forward and essentially become part of our national debt.
Okay, that helps. Any additional questions? Please, Admiral.
Thank you, Mr. Chairman. Thank you, Attorney General. I have a process question. If the citizens of Idaho, in some form, find that they think it's to the benefit of the state to consider what I would call a modification, a modernization of this agreement. How does that get done? Who initiates the action? Is there any structure or process that allows, for lack of a better term, a negotiation between the state and the federal government?
Mr. Chairman and Admiral, the agreement itself doesn't provide any sort of structured mechanism for that purpose, but the governor and the attorney general would engage in dialogue with the department as to what some potential changes would be. And while I'm on that point, I would say that I reflect the feelings of Governor Batt, that this agreement was designed to solve a problem. And we did the best we could under the circumstances that were before us, but none of the provisions of that agreement are sacrosanct. But we cannot at the same time retreat from the places where we have been, that if there can be improvements made, dialogue is the appropriate way to find that. I personally participated, for example, in the recent amendment with regard to the commercial testing, and you're familiar with that, Admiral, that it really fit within the confines of the construct of the current agreement. But what we did was provided some sideboards to how that would happen, and to assist the site at fulfilling its mission. So again, my point being that there's nothing perfect about the agreement, but we really have to stay where we are in terms of recognizing where we've been, and if we can improve, those things may be very helpful. But again, that's accomplished through a dialogue.
Thank you. Any other questions? Okay. Mr. Attorney General, having you here is a real honor. And we may have some side follow-ups as we get farther into our research and get more information back, but having you here, we really appreciate that. Thank you for giving us that time.
Thank you, and I would simply add that I checked quickly the Chinese proverb, which perhaps may have actually been from English. May you live in interesting times, and over the last couple of days, I would say I have lived in interesting times.
Well said. Thank you again.